My name is Michael Young, and I'm a lawyer who handles life insurance disputes. In this video, I want to talk about a very important concept involving denial of life insurance claims. But before I do that, I want to encourage you to please hit the like button and also subscribe to my videos. The topic of this video is the intent to deceive standard. And let me explain why that is so important. A common reason for a life insurance company to deny a claim for payment is they claim that the policy should be rescinded, that it never should have been issued because the insured, when they filled out the policy application, did not correctly answer some of the questions. Now, it could involve the amount of assets that they owned or their income. More commonly, it's conditions regarding their health, because an insurance company in the underwriting process obviously takes age and health are very important factors when they're deciding whether or not to issue a policy or how much to charge. Now, life insurance companies don't always do a whole lot of due diligence on their policies. Sometimes they will write them with fairly loose standards, and then they will come back and do what I would call post-claim underwriting, which is when they get a claim in, they will then take a look and see, look at the policy applications with a fine-tooth comb, go through the medical records to see if the applicant had incorrectly answered anything on the application regarding their health history, issues like that. And in Texas, a policy can be rescinded if there was a material misrepresentation on the application. And so what Texas courts consider a material misrepresentation is an answer that had it been answered correctly, that the insurance company would not have issued the policy. However, for a long, long time, Texas has followed the intent to deceive standard. And what that means is it's not enough for the insurance company to show that the applicant failed to disclose something or answered incorrectly. Instead, the insurance company also has to show that the applicant intended to deceive the insurance company, that it was an intentional misrepresentation. And this is very important for a couple of reasons. First of all, these policy applications can have fairly short form questions, and they can have compound questions. And some of the medical conditions that they ask about, while a doctor may know what they are, a layperson may not. And there may be very little guidance on answering these questions. So a person may say, no, I haven't had a neurological issue, and then the medical records come up with a series of headaches and migraines. Well, that person may not have known that that's a neurological condition, whereas the insurance company later on may claim, oh yes, and there's issues with strokes, things like that. So the insurance company just can't rely on the fact that it was a misstatement. Second of all, it becomes very important because insurance companies will try to convince the court that the case should never go to a jury, that the case should be dismissed based on a summary judgment ruling. Well, it is very hard to get a summary judgment granted on an issue of intent, because that requires the finder of fact to try to get inside the head of the applicant. In courts, judges are very reluctant to grant summary judgment on those issues and instead find that that's the province of the jury, that it's up to the jury to decide. And frankly, a jury might not be very sympathetic to a life insurance company that asks very short form, vague, compound questions rather than doing due diligence up front and then attempting to rescind the policy later and not to pay the family members, the designated beneficiaries, because of inaccurate or alleged inaccurate answers on a policy application. This is very, very sophisticated, complex area, and it's important that you contact a lawyer who is experienced in evaluating life insurance cases.